Welcome to the course on medical law. This lecture will be about health policy formulation and intellectual property rights. The concepts covered in this lecture are health policies in India, the implications of the TRIPS agreement, health policy in the post-TRIPS era, intellectual property and healthcare, public health a priority. The keywords of this lecture are public health, health policy, TRIPS, product patent and evergreening. The issue of maintaining equilibrium between intellectual property rights and public benefit has been a prominent topic of debate for a long time. After the signing of the TRIPS agreement, countries around the world had to incorporate intellectual property rights into their domestic legal system. So, this had significant impact over all the industries that are existing at that time, including the pharmaceutical industry. TRIPS specified the standard norms that has to be followed while implementing intellectual property laws. Incorporation of intellectual property concepts into the legal system led way for internationalization of domestic legislations and thus had significant impact over the pharmaceutical industry. They aim to strike a delicate balance between safeguarding the rights of innovators and prioritizing public health. So, the significant impact on the pharmaceutical industry had adverse effects in achieving the objectives of public health. So, on the one side, the interest of the innovators has to be protected under the intellectual property laws, but at the same time the priorities of public health also has to be addressed. So, finding a fine balance between these competing interests became a challenge for all the developing and underdeveloped countries around the world. The TRIPS agreement, which is a multilateral trade agreement among all members of the World Trade Organization or the WTO, established the basic standards for intellectual property rights, specifically addressing the issue of patent rights. The TRIPS mandated member governments to enact robust legislations regarding intellectual property rights, while also providing provisions for emerging and impoverished nations to engage in trade with other countries and foster an environment conducive to innovation and creativity. The TRIPS agreement provided for standardization of intellectual property norms across the world. So, it provided for establishing basic standards which all the countries have to adhere to. So, the domestic legislations specifically with regard to intellectual property rights had to be changed, especially in developing countries and underdeveloped countries. It also had specific provisions regarding the issue of patent rights. The TRIPS mandated that member countries should enact robust legislations regarding intellectual property rights, but it provided some flexibilities that the emerging economies and impoverished nations can utilize, which will give a leeway for a certain years of time. India, being a developing nation, compliance with TRIPS required many changes at the law and policy level. In India, access to reasonably priced medicines and healthcare is considered as a fundamental right guaranteed under Article 21 of the Constitution. India has developed its own TRIPS compatible intellectual property regime, which is seen by many as an exemplary instance of using TRIPS flexibilities by a developing nation. So, as a developing country, India had to make several changes in the legal system in order to incorporate the standards of intellectual property rights prescribed under the TRIPS agreement. But in India, access to public health is considered as a fundamental right which is guaranteed to all human beings. So, when the considerations given under the TRIPS agreement are incorporated into the legal system, it became a challenge for the government to find an effective balance between the competing interests. But India utilized the flexibilities provided under the TRIPS agreement for the developing countries and developed a legal system which effectively balances the competing interests. This is considered as an exemplary instance of using TRIPS flexibilities by a developing nation. Health policies in India. Traditionally, health policy in India has focused on achieving fairness and equality. Recently, the scope of the topic has expanded to include universal healthcare, which refers to provision of affordable healthcare to all people of a country. Ensuring availability of health facilities to a huge population that our country is possessing is definitely a challenge. India, despite its emphasis on equity, accessibility and quality, has a significant burden of addressing public health requirements of a huge population. Following India's independence, the government took direct action in the healthcare industry by establishing a network of public hospitals and primary health centers to provide medical services. So initially, it was completely government's responsibility to ensure availability of public health facilities to the huge population. However, healthcare system was hindered by numerous shortcomings. The National Health Policy introduced in 2002 mandated that the states prioritize universal health care by carefully assessing its capabilities in a practical manner. The policy paper acknowledged that its low capability in terms of infrastructure and resources were a significant obstacle in achieving universal access to health care. The 12th five-year plan has identified universal health care coverage as a primary objective, suggesting a novel approach that involves integrating insurance, outsourcing services and advocating for the use of generic pharmaceuticals through revisions in prescription of drug policies. Obtaining of affordable medications continues to be a significant concern, and any strategy or innovation that helps lower expenses would be highly beneficial to the population present in our country. Over the time, the state's failure to meet the population's health requirements has led to expansion of private healthcare industry as well. So initially, the responsibility of providing public health infrastructure to the population around the country was the responsibility of the governments. So governments initiated hospitals and other health facilities which could be accessed by the general public. But because of the failure in meeting the expectations of health requirements, it also led to the expansion of private health infrastructure in the country. In India's policy and law, significant changes were brought about due to the signing of the TRIPS agreement. Indian patent law underwent 3 amendments between 1995 and 2005 in order to conform to the requirements or comply with the standards prescribed by the TRIPS agreement. The Patents Amendment Act of 1999 incorporated the mailbox procedure in accordance with Article 70 Clause 9 of the TRIPS agreement. This procedure allowed pharmaceutical innovations to be stored in a mailbox for examination in 2005. In 2002, the second amendment implemented a patent term of 20 years. In this case, the responsibility to provide evidence of method patent infringement was shifted and the conditions of compulsory licensing were also altered. Finally, the Patents Amendment Act of 2005, which is the third amendment, provided for comprehensive patent protection to pharmaceutical innovations and significantly changed the patent law which is in force in the country. The product patenting which was introduced in the pre-TRIPS era. Prior to 1972, Indian pharmaceutical business heavily relied on imports, resulting in majority of the pharmaceuticals being considered too expensive for the general population. The political and policy advancements in the early 1970s, including the coming into force of the patent legislation in 1972. The legislation, even though it was enacted in 1970, came into force only in 1972, and subsequently the Drug Price Control Order of 1970 established the groundwork for robust pharmaceutical sector in the country. The Patent Act of 1970 prohibited granting of product patents in the field of medicines, while the Drug Price Control Order imposed price regulation on significant number of pharmaceutical products. The public sector's emphasis on pharmaceutical business and implementation of the rules that restricted the influence of multinational corporations contributed to a policy climate that fostered the expansion of domestic firms. As a result, India emerged as a significant global supplier of pharmaceutical products. During the pre-TRIPS era, the lack of product patents enabled domestic manufacturing of patented medications at a significantly lower expense, while process patents incentivized generic business to decrease the production expenses of the drugs. India's full adherence to TRIPS framework in 2005, which permits product patents, has altered the strategic choices available to Indian pharmaceutical companies. So, during a period between 1970 and 2005, product patents were not available for pharmaceutical products in India. So, this led to a scenario where Indian companies could use the new innovations which are patented in foreign countries. But at the same time, process patent was provided in India. So, this led to proliferation of Indian generic industry, or the pharmaceutical business thrived in India. Slowly, India became a global supplier of pharmaceutical medicines. But after 2005, India had to comply with the TRIPS framework, and thus product patents was reintroduced for pharmaceutical drugs as well. The most notable and contentious modification after the TRIPS was the removal of Section 5 of the Patent Act of 1970, which allowed for granting of product patents in the field of pharmaceutical and other chemical innovations. According to Section 5 of the Patent Act, patents could only be sought for techniques or processes of manufacturing food, medicine, pharmaceuticals or chemical substances, and not for innovations themselves. Following the implementation of the TRIPS agreement, India transitioned to a product patent regime, wherein exclusive rights were conferred upon a particular medication irrespective of the method of production. The transition to product patents had a clear and immediate effect on the accessibility and cost of pharmaceutical drugs in the country. The implementation of a robust patent protection resulted in elevated pricing of patented medications and hence reducing their affordability for general populace. So, after the signing of the TRIPS, India had to implement product patent regime for pharmaceutical drugs as well. But TRIPS provided the flexibility which was exhausted in 2005. So, through the 2005 amendment, product patents was reintroduced in India, which led to a scenario where pharmaceutical innovations were granted patents which was substantially more than the method patents or the process patents which were being granted in India between the period of 1972 to 2005. This resulted in escalation of price of patented medications and significantly affected the affordability of general population. This presented difficulties especially in the healthcare industry, where the availability of cost effective medications is essential. The TRIPS agreement incorporated provisions and measures to effectively deal with public health concerns while allowing for flexibility and ensuring protection. An example of such a provision is the statutory authority to give compulsory licenses, which authorize the government to issue licenses to third parties for the production of generic versions of proprietary medications without the patent holder's approval. So, when the TRIPS flexibility is exhausted and India had to implement the product patent regime, there need to be a balance which has to be ensured between the interest of the patentee and the general public. So, in order to address this, the governments introduced compulsory licensing provisions and several other exceptions which will take care of the interests of the general public. The 2002 Act implemented a patent term of 20 years, aligning the provisions with Article 33 of the TRIPS agreement. According to Article 33, patents should be protected for a duration of 20 years starting from the date of filing. Previously, the term of patents for inventions pertaining to method or process of producing a substance that is utilized or can be utilized as a food, medicine or drug was either 5 years from the date of sealing or 7 years from the date of the patent, whichever is less, as stated in section 53(1) of the Patent Act prevailing at that time. Regarding other innovations, patent term used to be 14 years from the patent's date, as stated in section 53(2) of the Patent Act prevailing at that time. But all this was modified and a uniform period of 20 years was introduced for all inventions which are patentable in India. The term evergreening is used to describe a technique where pharmaceutical companies prolong the patent protection of a drug by acquiring an additional 20 years for patents by minor modifications or alternative versions of a drug without necessarily improving its medicinal effectiveness. So, in order to be eligible for grant of a patent, the pharmaceutical drug which is developed should have novelty, inventive step and industrial application, and it should not be an invention which is not patentable as provided under section 3 of Indian Patent Act 1970. But pharmaceutical companies followed a practice where after the expiry or before the expiry of the patent of a pharmaceutical drug, they will apply for a new patent for some minor modifications or alternative versions of the patented drug. Once this patent is granted, this will significantly improve the protection or monopoly that is available to the pharmaceutical company for another 20 years. But section 3, which was introduced through the amendment for complying with TRIPS, addressed this issue and made many of these things as non-patentable innovations. Section 3D read that the mere discovery of a new form of a known substance or mere discovery of any new property or new use for a known substance or of mere use of a known process, machine or apparatus, unless such known process results in new product or employs at least one new reactant, is not an invention under section 3. This clause was introduced with an intention to prevent the practice of evergreening and safeguarding the interest of authentic innovators. So, this provision ensured that the mere discovery of a new form of a known substance or the mere discovery of a new property or new use of a known substance will not qualify as inventions as provided in section 3. If they are not qualifying as inventions, then they become non-patentable under the Patent Act 1970. In 2005, an amendment was made to section 3D, which introduced a requirement for the drug to demonstrate therapeutic efficacy. This requirement focused on drugs' ability to provide therapeutic benefits rather than only on improvements in its physical qualities or stability. This led to a very interesting case. Novartis, which is a pharmaceutical company, submitted an application to the Chennai Patent Office for a drug called Glivec, which was modified version of their 1993 patented anti-leukemia treatment. The application was rejected by the Assistant Controller of Patents and Design of the Chennai Patent Office, citing the newly amended section 3D. Novartis petitioned before the court to declare that section 3D of the Patent Act is not in accordance with the TRIPS agreement and is also in violation of Article 14 of the Constitution. The main argument regarding the breach of Article 14 of the Constitution of India revolved around the arbitrary discretionary authority granted to the patent controller in determining improved efficacy. So, under section 3, unless there is improved efficacy, the invention becomes non-patentable. But who will decide as to whether the newly applied drug is having improved efficacy or not? The discretion is with the controller of patent. So, the main argument is that the grant of this arbitrary discretionary authority to the patent controller in determining improved efficacy violates Article 14 of the Constitution of India. The court stated that the purpose of patent system is to deter the prolongation of drug patent beyond 20-year period, thereby enabling other companies to manufacture and sell the medication. The court stated that the purpose is to prohibit evergreening, provide convenient availability of life-saving pharmaceuticals, to fulfill the constitutional duty of providing healthcare to the population. The court took into account the public interest factor in a notable manner while making the decision. The issue of right to health is a matter of concern in various regions globally. Given that affordability is a significant determinant of accessibility, this ruling holds great importance as it enables impoverished nations to obtain the patented drug at reasonable price. To conclude, the TRIPS agreement has had substantial impact on the intellectual property legislation in India, especially the patent laws, resulting in availability of medications. In India's ongoing efforts to manage the intricacies of intellectual property legislation and the TRIPS agreement, it is crucial to establish a harmonious equilibrium that fosters creativity, protects public well-being and guarantees availability of vital medications for its citizens. The references of this lecture can be seen here. Thank you very much for listening to this lecture. I hope you are enjoying the course.